Okay, so let's go on the record on cause number DC 181418. Council, make your appearances.
Morning, Your Honor. Brandon Tittle on behalf of Jeremy Haltom.
David Gibson on behalf of Donald Triplett. And DFW Design.
All right, are we ready to proceed?
Yes, Judge.
Yes, Your Honor. So today we're here on a motion to compel, request for sanctions, and a request for continuance. The last time we were here, we had a discussion on the opposing party's request for to open the case for the limited purpose of having the list pendants removed. If Your Honor will recall, I asked for discovery, expedited discovery, before we had a somewhat of a limited evidentiary hearing on the request to have the list pendants removed. You allowed me 5 interrogatories and 5 requests for production and 3 total hours of deposition time to be split up how I wanted to do it. After we had the hearing and you entered the order, I sent out discovery request for production of documents, and a set of interrogatory questions that were done in pursuant to your order. So 5 total requests for production, 5 total interrogatories. They're attached as Exhibit E and Exhibit F to the motion. That was sent and served on March 10th, 2020. We also, after doing that, we sent a notice of intent to take Mr. Triplett's deposition. We also sent the same notice to Triplett's counsel to depose his husband, Donnie, what is his name? Donnie. Unfortunately, Triplett's counsel, David Gibson, did not accept service on behalf of Triplett's husband, and we've been unable to successfully serve Mr. Escafe after repeated attempts by a process server and from the McKinney Sheriff's Office. And so we were unable to have a deposition with him. We received answers or objections and responses to the production of documents from Triplett on April 9th, 2021. His responses are attached as Exhibit I at the very back of the motion. Basically, every response to the request for production and for the interrogatories is that Triplett pled the Fifth. And if Your Honor will recall, he's indicted in Dallas County on a felony charge directly related to the issue that we're talking about, which is the investment that Triplett brought to Jeremy Haltom for the amount of about $150,000. That loan was made on different types of fraudulent misrepresentations that then Triplett used to fund all sorts of remodeling and renovation work in his house, in his homestead. It was our allegations in the complaint that he used basically 100% of those, the fraudulently received proceeds to remodel his house. So based on, I guess, he didn't explain why he's pleading the Fifth, but that's just my understanding based on the facts of the case, why he would plead the Fifth. We then sent a privilege log request on April 16th, 2021, requesting that Triplett provide a privilege log to identify all the documents that are considered privileged under the Fifth Amendment, because he did not discuss any of that information in his objections and responses to discovery. We asked that he provide that privilege log in 10 days, which would have been April 26, 2021. Obviously, we've still not received a privilege log. Under case law, his blanket assertion of the Fifth Amendment privilege is obviously unlawful. It's up to the court to determine whether he is pleading the privilege in good faith and whether all the documents that he's saying are privileged are actually privileged. We can't prepare for a hearing on the evidentiary hearing on the removal of the list pendants without having any kind of documents, without being able to go and depose Mr. Triplett. So he's using this Fifth Amendment basically as a shield and a sword to try to get the list pendants removed. If he's going to act or say that everything is protected by the Fifth Amendment, we would ask that either he provide a detailed privilege log so we can review what documents that he's saying are actually privileged, or we have a special master be appointed so that they can help this review. But simply going to an evidentiary hearing without any of this information would be grossly unfair and prejudicial to my client. So for the time being, we're asking for sanctions for us having to tee up this motion, because obviously they're not complying with our privilege log request. And that we're asking for the evidentiary hearing on the lis pendens be continued until we can have someone analyze whether they're pleading the fifth appropriately. Like I said, there's no record of what documents are actually privileged. They're just asserting a blanket assertion of the Fifth Amendment, and we have no idea what documents are actually privileged. And until that happens, I don't think we can go forward on their request to have the lis pendens removed.
Response?
Absolutely. It's ironic that Mr. Tittle raises the sword and shield, given the fact that they are the ones that filed a criminal complaint on the identical facts and issues. They are the reason that Mr. Triplett is asserting the Fifth Amendment. In their motion, after setting forth the factual background of this particular motion, the very first thing they say in paragraph B on page 3 is, "Oh my God, Judge, there's a criminal complaint pending. Don Triplett is a bad guy." And then they point out that the allegations in that criminal complaint are exactly the same as the allegations in this complaint. And now they wonder why he's asserting the Fifth Amendment. Secondly, I don't think they understand how the Fifth Amendment works. Mr. Triplett has asserted the Fifth Amendment to each and every individual question. When the courts say you can't make a blanket objection of the Fifth Amendment, what they mean is you can't show up at a deposition or a trial and say, "I'm just not going to testify," which is why you see all the time question followed by objection, question followed by objection. It's painful and it's tedious, but that's what a blanket objection to the Fifth Amendment means. Regardless, there is a huge backstory that has not been shared with the court intentionally. There are 14 related proceedings between the Vaux, Mr. Haltom, and Donald Triplett. Mr. Triplett himself has been deposed by Mr. Haltom and his attorneys 4 times in 2 different proceedings, twice in bankruptcy court, twice in state court. Each time they took up every minute of available time. In the bankruptcy court, they took the full 2004 examination and then went back to the court and asked for more time and got more time. He has been deposed 4 times. They have taken 8 depositions total that we're aware of. God and Jeff Bragg alone know how many depositions they took in the related FELSA proceeding, but they have had way more than enough evidence to survive this motion that we have brought, if they in fact can. And I want to point out a couple of things. Number one, when they filed a criminal complaint, they obviously had some evidence on which to do so. Otherwise, they would have been in violation of their own ethical obligations in presenting it. A grand jury must have seen something because an indictment was issued. They had to have overcome that threshold. Now, we know you can indict us. I think it's a ham sandwich. I never can remember if it's ham or cheese, but they had to present something to the district attorney. Secondly, they filed this lawsuit 5 years ago, I believe. They had to have some basis to file this lawsuit. Otherwise, they were violating their own ethical obligations. They walk into this court now and say, "Judge, we can't proceed because we can't get evidence," when we've been involved in litigation with Mr. Triplett for 5 years in 14 different venues. That is just a flat out misrepresentation. Now, let me take a deep breath here and point out what the law requires. Under the property code, which is the basis for our motion, 12.071, we filed a motion to expunge the lis pendens. They are seeking to have this court impose a constructive trust on Mr. Triplett's homestead based on what they allege is money fraudulently taken from Mr. Haltom in an unrelated transaction that was used to remodel or redecorate Mr. Triplett's homestead. They're not even alleging that the funds were used to purchase the homestead. They are alleging that it was used to remodel the homestead. The homestead is sacrosanct. Mr. Triplett made that or filed that exemption in the bankruptcy court. Haltom did not object to it. No one objected to it. The bankruptcy court has expressly held that the homestead is no longer part of the estate, and you, Your Honor, are entitled, because of that ruling, to proceed on this matter. So, and where I'm going with this is, under section 120071 of the property code, they have to establish one of three things. Strike that, I'm saying that backwards. The court shall order the notice expunged if the court determines that. Number one, this is super important. The pleading on which the notice is based does not contain a real property claim. Number two, and these are disjunctive, not conjunctive. Number two, the claimant fails to establish by a preponderance of the evidence the probable validity of the real property claim. Or number three, there's a notice issue. We're not alleging the notice issue. That's not before the court. They provided notice. Number one and two are what we moved on. They have to establish that they are asserting a real property claim. Otherwise, their case dies and the lis pendens comes off. And in order to make that analysis, the court, it's just like a summary judgment in this respect. The court assumes that everything they're saying is true in their pleading, on the face of the pleadings, like a 12b6 motion. The court assumes everything they're saying is true. And if it still doesn't meet the threshold, the lis pendens has to be expunged. The court does not need to see or hear or read one iota of evidence to make that determination. If and only if the court concludes that there is a real property claim, then you go to two. And if you read number two, it's the claimant fails to establish by a preponderance of the evidence the probable validity of the real property claim. Therefore, the court has to conclude that there is a real property claim. And I mention this because in a normal world where Mr. Haltom hadn't filed a bogus criminal complaint against my client, and Mr. Triplett could testify, he would testify, but he can't because he risks going to jail by virtue of what they are alleging. But you don't need his testimony in order to determine part one of our motion. Is there a real property claim?
I think we're dealing right now with discovery requests, right?
This all relates to the same thing, Judge. They don't need any evidence to proceed on the motion set in 4 days. None. As far as the discovery is concerned, they have attached the interrogatories and the request for production that they want my client to answer to their motion. And each and every one of those items goes to the exact issues in the criminal complaint. This is the same complaint. It's not like they're coming in here and saying, Judge, we have a promissory note case here, but he defrauded us on a separate real estate transaction over here. They are saying this transaction is the basis of a criminal complaint. There is not one single question that Mr. Triplett can answer in any way, shape, or form without waiving his Fifth Amendment privilege. And if the court—
So, Mr. Gibson, okay, I appreciate it. If I had more time, I would I get—
No worries, I get wound up. Sorry.
So,
Can I respond?
So let's kind of dive down a little bit here on what is required when you're analyzing a discovery request, a written discovery request in the Fifth Amendment context. And I'm kind of looking at O'Connor's. If you have this year's O'Connor's, look at page 591 on the bottom. It says the Fifth Amendment privilege against self-incrimination also applies to document production as long as the incriminating documents are personally connected to the witness. And it cites In re Speer, S-P-E-E-R, from Fort Worth Court of Appeals. That is, the documents must have been written by the witness or under the witness's immediate supervision. And finally, it says the person asserting the Fifth Amendment privilege must raise it in response to each specific inquiry, or else the privilege is waived. And so I looked at the discovery request. I really do think that there needs to be some kind of privilege log. For example, they ask you for all of the emails. I don't remember how it's worded exactly. All of the emails, blah, blah, blah. Let's see. There's a lot of instructions here. So, for example, produce any and all emails, text messages, electronic messages, chats, recording of telephone conversations, transcripts of telephone conversations, notes of telephone conversations, blah, blah, blah. between or among Triplet and Haltom and or Donnie, discussing, mentioning, referencing, or concerning any acquisition of or investment related to restoration by Triplet or DFW for the time period of January 1st, 2013 to January 1st, 2017. I mean, clearly there's a lot of that one would not be, there's going to be text messages and emails that were sent to your client.
By Mr. Haltom.
Right. To
which
your
he
client.
would have.
Well, Mr. Gibson, to your client, you didn't object on the basis that it's in their care, custody, or control. You just objected on the Fifth Amendment. Fifth Amendment would not protect that. There'd also be emails, other emails that they may be parties to, that anything that your client didn't actually author would not be privileged under the Fifth Amendment. Also, there's going to be emails and documents that are not going to, I imagine, that will not be incriminating for this criminal complaint, given the breadth of those email requests. And so you do really need to go through each individual email and make a determination whenever they respond to an email, whenever somebody else responds to an email, anything like that, that's not protected by the Fifth Amendment. And so there needs to be a dive down on this to make a determination, is the Fifth Amendment even apply to each individual document? You can't just say every document is covered by the Fifth Amendment because I have a criminal complaint. It has to be something that was authored by your client or somebody who's in supervision of, and it has to be incriminating. And there's maybe every email fits within that, but I find that very hard to believe because there's going to be emails back and forth. So I'm going to order, I guess, a privilege log to be produced that goes through each individual email. And that's just the first one, but I have a feeling they're all going to kind of be the same. Second one looks pretty similar.
Your Honor, we can create a privilege log for each and every one of those items. I do want to address one last point with the court, unless Your Honor obviously has more. I don't want to.
No, I want to look at the interrogatories first. Same with the interrogatory. There's not going to need to be a privilege log. You're going to, anything that your client stated that's incriminating for the criminal matter, you can assert the Fifth Amendment, but they're asking about also statements that you claim were made to you. There's no way that a statement made to you by the opposing party, your client, that made by your client by the opposing party is going to be incriminating you that I can think of. And so you have to, I mean, it's the same thing for the communications. So you'd have to go through and identify conversations, non-incriminating conversation, any non-incriminating conversations, as well as anything that was said by the opposing side, because that's not going to obviously be incriminating. So anything non-incriminating your client said, and anything by the opposing side or other people that were stated and asked for here.
May I ask the court a question?
Sure.
We have a motion pending on the 24th of this month to
Right.
free up the equity in Mr. Triplet's home, which he desperately needs to defend himself in the criminal and civil proceedings, and they know that. That's why this is a delay tactic. If we non-suit or dismiss or file an amended motion, getting rid of item number 2, will the court still consider item number 1, which is a pure legal pleading 12b6 type issue, next week? And I'm happy to answer the discovery in accordance with the court's ruling, but we would like to get a ruling on the pure legal issue that cannot be addressed by evidence.
Your Honor, we can't answer those questions without being able to depose the defendant and get the documents that we want to see what was actually done. Maybe he did pay part of the mortgage off with these proceeds. We don't know that. We've actually never done discovery on this lis pendens issue. What we've done is discovery on all sorts of other issues related to the debtor's bankruptcy and whether his bankruptcy should be non-dischargeable under Section 727, not whether this lis pendens is valid or not. We've never gone to a deposition on this matter that I'm aware of, or at least I didn't represent the party or Jeremy Haltom if that did happen. I'm not aware that it did. The big issue here is that the property code is apparently doesn't allow for lis pendens if you didn't buy the home, or at least this is their allegation, if you didn't buy the home with the proceeds. But the property code doesn't take into account this situation where someone defrauded someone out of funds. That person used the funds for to increase the value of their homestead. The homestead was never meant to shield someone from when they committed fraud. It's not supposed to shield them from criminal activity. And that's exactly what happened here. And they're wanting to say, oh no, we don't get the benefit of the lis pendens, even though $150,000 was used to benefit the homestead. If he would have had a contract with the debtor as a contractor, he would have had an M&M lien that would have been valid on the homestead. But because they defrauded him out of those exact same funds, he's somehow not allowed to have a lien on the homestead. The homestead is not at all supposed to be able to do this. And so I would like to see a lot of what happened at the time that this fraud took place, what statements were made, what he did with the proceeds. And without being able to depose him, without being able to see any of the documents, I think it's grossly prejudicial to my client to proceed to an evidentiary hearing on this without having any discovery.
Your Honor, I would like the court to take up this issue on Thursday of next week because he is dead wrong on the law. And the court can decide next Thursday if I'm the one that's wrong on the law. But I think you will find that Texas law and the law across this country says it doesn't matter if it's fraud.
That's incorrect. You've cited no cases in your pleadings that said this. You've also not even formally responded to my actual document.
Well, let's hear it Thursday, Judge, on that issue. My client is in serious peril here.
And you've cited no case law in support of that position.
You keep saying Thursday.
24th. Is that Wednesday? I thought it was Thursday.
24th is a Monday. It's next Monday, right?
Oh, I'm sorry. I was looking at June. Yeah, we're talking about 3 days from now. Hear the legal issue 3 days from now. If we're wrong, he still gets his discovery. If we're right, this matter is over.
Your Honor, this issue has not been briefed.
I'm sorry. This is state court. We'll file an amended motion if you want to see the case law that you haven't been able to find. The court will see it.
I think we need to have this issue briefed up to determine whether we even have the ability to go forward. We don't have any discovery to determine whether you're right or wrong.
Well, Your Honor, it's not my fault that they haven't done their homework. You will see the case law, and I'm happy to file an amended motion showing that case law. But we can hear that number one item on Monday, and that doesn't impact anybody's ability to get discovery.
So are you requesting let me just make sure I understand this because I haven't looked at the stuff on the 24th yet. Are you asking for an evidentiary hearing on Monday? Me? No.
No, Your Honor, that's what you scheduled when they came up with this argument the last time. They came in shouting the exact same argument the last time we were here, and you said, I think he's entitled to discovery under the rules for removing a lis pendens. That's what the statute says. When you're removing a lis pendens, you're entitled to a evidentiary hearing on the issues.
It actually doesn't say that, Judge, but item number one, 12.0071C1. The court shall order the notice of lis pendens expunged if the court determines that the pleading on which the notice is based does not contain a real property claim. That is in the nature of a 12B6. I am perfectly happy to drop number 2 in order to be heard on Monday on the legal issue. They didn't even ask for a continuance last time. The court gave it to them.
That's actually not correct. He wanted to set an evidentiary hearing and gave us an opportunity to go to discovery.
Like I said, you didn't ask for one. The point is, Judge, it's a legal issue, and we don't need to kick this off another 30 days while my client is dying in 14 different court proceedings because he can't access the equity in his home. Well, this is a real world problem for Mr. Triplett, which you can hear more about on Monday and get these other 15 lawyers addressed today.
Your Honor, without having discovery, we can't answer the question.
I'm looking at 12.0071. It says apply to the court. So you were talking about 1 versus 2, right? So is that 12.0071C 1 and 2 is what you're talking about?
Correct, Your Honor. And if we go forward on subsection 2, they have an evidentiary burden, and so fine, we can get them the evidence. And if we don't win on Monday, we'll be back here in a month. But
yeah,
Mr.
you can't
Triplett
go forward on 2. They're going to need discovery on this.
Understand, I am non-suiting item 2 right here, right now on the record. We want to be heard on Monday on item 1.
Just on item 1.
Yes, Your Honor.
I mean, I kind of agree with him. I don't see why you would need discovery on C1. It just says the pleading on which the notice is based does not contain a real property claim. On that narrow issue, I don't know that you need discovery. Before, when he was asserting C2, I think, and according to 12.0071, it does allow evidence, declarations to be filed, and it permits evidence on the motion to be received in the form of oral testimony, and it allows for discovery. All of those, I think, relate to C2, not C. I don't know how C1 you'd need any of that. I will tell you, Mr. Gibson, if you haven't briefed this issue, I will tell you what I do in 95% of cases. If you show up with new briefing on the day of the hearing or right before the hearing, I'm going to continue it anyway. But, if you want to go forward on C1 and it's been adequately briefed, I'm happy to go forward on Monday, but I'm just warning you that if you submit additional briefing the day of, I'm not a gotcha court. And so I'm going to give the other side an opportunity to brief it too.
And I respect that, Your Honor. And in light of that, if the court can reset us very, very quickly, like Friday or the following Monday, that I think should address both parties' concerns, because the case law, which we will be happy to present to the court in a brief, probably can't do it today because we're in a mediation today. I don't mind a short continuance, but 30 days could really put my client in prison.
I'll reset this. I'll reset it 2 weeks. So, and all the briefing, Mr. Gibson, you need to get the briefing on file. I want you to prepare an order on this. I'm going to continue this for 2 weeks. We're going to set this on. Wait a minute, it's 2 weeks going to be Memorial Day.
Your Honor, can I have a quick response to this before we continue to set this? The statute of limitations has been.
Let me just say this: if you want to make a brief response to this, I may change my mind and not move it. So, do you want a response?
Well, so my response is I don't think we're necessarily barred from amending our pleadings, because the statute of limitations has been told since 2019 when they filed their bankruptcy case. So to the extent we get new evidence, we can amend the pleading to say whatever we need to. And for instance, he paid off part of his mortgage with this fraudulent money that he received. We don't get to do that because we don't get discovery.
I don't disagree, Judge. He can amend his pleadings between now and the 14th of June.
I can't amend my pleadings if we don't get discovery.
They've had 3 years to do that.
We
Judge.
don't. We've been in bankruptcy for 2 years. The statute
in which they've taken
for 2 years.
8 depositions.
No, we don't get to do anything because the automatic stay.
Guys, I'm going to move it 2 weeks. Mr. Tittle, you can brief this issue about whether or not you can get discovery on this issue. My analogy, and I don't know the law on this, I've had a few of these motions to expunge lis pendus, but not enough. I can say I've done 50 of them. The analogy I'm thinking of is a 91A motion or a motion to dismiss under Section 74 of the, for medical malpractice cases. Those usually don't allow you to have discovery when you're trying to dismiss something on the pleadings or an expert report. But I don't know the law on this. So if you want to move for an additional continuance based on that, I'm happy to look at it. For now, I'm going to go ahead and move this for 2 weeks. Mr. Gibson, I want you to write this down very carefully. So you have until next Wednesday to file your additional briefing. Mr. Tittle, you have until the Monday after that, and you need to make sure you email him note as well as e-filing and all that stuff, or you can't just mail it to him. I don't know if people still do that, but I've seen that tactic. You need to email
Believe it or
him.
not, some do.
You can send it to him on Wednesday, email it to him on Wednesday, and the court.
Absolutely.
Email Rhonda as well. Then Mr. Tittle, you'll have until the next Monday to file any briefing that you need in response to his briefing, and then we'll have the hearing on
June 14th.
June 11th, which is 2 weeks from today.
June 11th.
Isn't that right? It's not 2 weeks from today.
Yeah, I was looking at the Monday. That's correct, Judge.
No, I'm sorry. It's June. 2 weeks.
June
from
14th is the Monday.
June 4th is Monday. Sorry, it's Friday. June 4th at 9:30 is when we're doing the next hearing. So June 4th at 9:30.
Your Honor, I have a hearing in this matter at 9 a.m.
Okay. How about 11? How about 11 a.m.?
I don't know if that's going to be enough time. We have 4 matters going forward on that at that time.
There are 5 law firms representing this plaintiff. 5 law firms, Judge.
Then if that's an issue, then let's do June 7th then. June 7th at 10 o'clock.
That works.
All right, guys. Mr. Gibson, make sure you get an order on this.
I shall. Absolutely.
Share it with Mr. Tittle. On the order, make sure that you put down that this was heard on May 21st, 2021, not on this day. Try to get Mr. Tittle's signature as to form, and then email it to Rhonda as well as e-filing. Okay.
You bet. Will do. Thanks for putting up with us, Judge. I appreciate it.
And Your Honor, you said that hearing was at 11 on the 7th?
10.
10.
On the 10th.
Okay. Thank you.
Thank you, guys.
May we be excused?
You may be excused. Okay, our next hearing, that went a little long, is Courtney Wayne versus Worco.
Yes, Your Honor, and Ryan Owen and Laura Benitez Geisler are here for plaintiff Courtney Wayne.
Your Honor, for Nazalms, I'm here for defendant Allstate.
Okay, let's go on the record on cause number DC 199994. Counsel, make your appearances.
Your Honor, Ryan Owen and Laura Benitez Geisler are here for plaintiff Courtney Wayne.
For Nazalms, for defendant Allstate.
Okay, so this is kind of an unusual motion, a motion to adopt expert witnesses. I don't know that I'm not sure I've ever seen that. So kind of tell me what's going on here.
Sure. So, Your Honor, as I stated, I represent Allstate, and we're seeking to adopt our co-defendants' expert witnesses. So this is a case where plaintiff filed a suit initially against the co-defendant, Worku, and later added plaintiff's own UIM insurer, Allstate, who I'm representing. So co-defendant Worku retained and properly designated their medical experts. It's 2 experts in question. It's Dr. Christopher Happ and Dr. Gregory Lacar. And so both of these experts, they wrote their reports in connection with the review of plaintiff's medical records and billing. And those reports were submitted to plaintiff's counsel, and plaintiff's counsel has noticed the notice issues are going to be really important for our argument here. However, though, co-defendant Worku has now settled out of the case. So they just dropped out. And that leaves us, defendant Allstate, at this time without any expert reports in the case. So we thought that the best thing to do, instead of hiring at this point in the case, hiring new experts, filing a motion for leave to try to get them in, and with new information, and we really have the same kind of, it would be on the same issues that the other experts opined on. We thought that we'd file a motion to adopt the other experts that the co-defendant, I guess, took with them at this time, because those would be experts and reports that the plaintiffs have seen, the plaintiff has seen, and has been on notice on.
What authority do you have, are you relying on to make this motion? I didn't see any case citation or, or rule.
So I don't think I didn't write the motion. It was an associate, another person, but I don't think that they relied on anything except for the fact that in order like to designate or adopt or get experts in some way at this point in the case, we'd have to have good cause. And we were thinking that.
Where do you get this good cause requirement from? Is it from a rule or a case or?
It's case law. It's case law. It's not included.
What case are you relying on?
Let me see.
Can you share screen it? Because I've not seen this argument that you've made, but I don't know that I've ever seen it before.
I don't think that the other associate included it in the motion. I think it was a pretty bare bones motion that.
Ms. Geisler, do you agree that it's a good cause standard, or do you know what case law or rule that they're relying on? Maybe I'm missing something.
And Judge, or sorry, Laura.
Miss Owen, Mr. Owen, I'm sorry. I don't mean to throw Miss. I know Miss Geisler, so I think Mr. Owen, do you know what rule she's relying on?
Yes, Your Honor. I believe that defendants were referring to Texas Rule Civil Procedure 193.6, more specifically A1, and that rule provides that if discovery is not supplemented in a timely fashion, the court, should exclude that evidence unless there is good cause for failure to timely make, amend, or supplement. And Your Honor, I'll point you to B as well, that the defendant does have the burden of establishing good cause or the lack of unfair surprise. And to your point just a couple minutes ago, really no arguments, no case law, no authority in their motion to support that.
So I guess why you're saying 193, and I'm not fussing with you because it's not your motion, but what you're saying is that they needed to do this because they failed to supplement their own discovery in a timely basis. And so they're trying to use this provision to kind of say, oh, look, we should be able to adopt another defendant's discovery, and that they should have that's where the good cause standard comes in, because they missed the original deadline.
Correct, Your Honor. And I don't mean to speak for defendants, but that's my assumption, is that they're relying on this good cause standard. Because otherwise this motion is simply a disguised motion for leave, in which they would need to prove good cause to have any sort of chance to admit this evidence under 193.6 or show lack of unfair surprise. But again, they have the burden of establishing both. And again, that is my assumption, that they're relying on that rule in order to kind of get around, or they're relying on this motion to adopt, which is unusual, to get around the requirements of an untimely designated expert witness.
I have a vague recollection that there is some case law on this topic about whether or not if one defendant non-suits another defendant one defendant is non-suit and the other defendant, whether or not they can rely on the other defendant's discovery designations. But I mean, there's no case law, there's no rule citation in this motion, so I'm not exactly sure. I mean, I don't want to rely on a vague recollection on a previous case that I heard years ago, but I do think there is some case law out there.
Your Honor, if I may, would it be okay if we amend the motion? Like I said, I didn't write the motion, but I would be really happy to find that case law, and then that would settle it, so we don't have to do it.
Yes, Mr. Owen, are you opposing this or not?
Yeah, we are. Yeah, we're going to oppose any sort of extension on their ability to amend the motion. And one of the reasons is that, just reviewing discovery from defendant WorkU, I'm hoping the defendant can point us in the right direction as far as where WorkU itself or himself actually designated these people as expert witnesses, because it looks like their last response for request discovery was on September 25th. At that time, they did not disclose any testifying experts in their request for disclosure. And then by the time that they were non-suited from the case, there's no expert witnesses really to even adopt. So I think that's really the first point here, is that they're trying to adopt something that WorkU never did. And then there's the timeliness issues that, even if they did actually adopt them, well, they need to show some good cause or lack of unfair surprise under the rules in order to be able to, the court to grant leave on this motion. It's essentially a motion for leave to extend the discovery time. And they just haven't shown either.
Ms. Barnos, I would encourage you to consider just passing your motion and then refiling it. I don't know that I want to just let you amend it. What you've done so far clearly does not establish good cause. It doesn't have any case law. It doesn't have any history. It's so bare bones. There's nothing here. And so I can rule on what I have before me, but you might want to just pass the motion, file a new one. And when is the case set for trial?
It's not until September of this year, Your Honor.
So yeah, I would be happy to pass the motion and then file again with that case law that you mentioned, and then it would be settled. The case law is gonna tell us which way what to do here in this situation when a co-defendant drops out of the suit.
Yeah, I couldn't hear that, but I think I understand what you're saying. All right, guys. Well, thank you so much. You guys be safe and just go ahead and file a new motion and maybe talk to the other associate that you need to get a little more detail in there next time. So, but you guys be safe, and we'll see you on the next one. Okay.
Yes, Your Honor. Thank you so much.
Your Honor.
All right. Our next motion is. Do we have anyone here on LaForce Entertainment versus Morgan?
Yes, Your Honor.
Okay. Are both sides here?
Yes, Your Honor.
Okay. Let's go ahead and hear argument on the TRO.
Okay. Caroline Harrison on behalf of LaForce Entertainment, and I wanted to just let Your Honor know that my law clerk, Erin Siegel, is here just observing today, and then my client, Glenn Roush, is also here. We are seeking a TRO today against defendant Adam Morgan. This case is about a former employee who is openly competing with and soliciting clients and employees from his former employer, despite the fact that he signed a binding and enforceable non-compete and non-solicitation agreement as part of his employment with LaForce. In addition, Mr. Morgan is believed to be using LaForce's confidential and proprietary information in the new venture that he has opened. Just to give some background, Plaintiff LaForce is a company that provides specialized DJ services and event production services in Dallas and Fort Worth area and in the surrounding counties. The services include providing audio-visual entertainment, lighting services, sound production, photo booths, DJ services, hosting services for events. Plaintiff LaForce employs several DJ personalities who have been specially trained by LaForce to provide its unique way that it does these events. Critical to their business is the relationships that they have created with venue managers, caterers, wedding planners, and event planners. Plaintiff has invested a significant amount of money and time into developing the services, the special way they do things, and their business reputation. Mr. Morgan was employed by LaForce 4 years ago. Prior to his employment, he didn't have any experience as a DJ or in any kind of event production services. So he was provided specialized training by LaForce that included closing sales, event production planning, referral source relations, music theory and history, equipment operations, LaForce DJ personality training, and how to do event productions in the unique way that LaForce does them. As an employee, he received confidential information, which included the specialized training, the identity and contact information of LaForce's referral sources, the method for pricing events, training materials, the artistic methodology that was specifically developed and used by LaForce, LaForce's marketing strategies, and their strategic plan. The non-compete that he signed is attached to the motion. Mr. Morgan signed it at the beginning of his employment relationship, and it was specifically aimed at protecting this specialized training and confidential and proprietary information that he was given.
Hey,
Under
Ms.
the
Diane,
term-
this email from Jackie Moore, did you take care of that for the move? The email?
Yeah.
Okay.
Oh, wait,
I can
Mr. Alexander, you need to mute. Okay, so go ahead, sorry.
Thank you. Under the terms of the non-compete agreement, it was drafted specifically to comply with 15.5 of the Texas Business and Commerce Code. Specifically, he was prohibited for 12 months after his employment ended from competing in a 4-county radius, Tarrant, Collin, Denton, and Dallas. And the things that he was prohibited from doing were narrowly drawn to just be the event production DJ services that he was performing while he worked for LaForce. He was also, as part of his employment agreement, he agreed not to solicit referral sources or employees for a period of 24 months. And that was during and after his employment for the time he was employed, as well as 24 months after his employment ended. He also had a confidentiality covenant under which he agreed not to disclose or use LaForce's confidential information for his own benefit or for the benefit of another during and after his employment. And what happened in this case is that LaForce learned through Jacob Hands, their operations manager, whose affidavit is also attached, or declaration is also attached to the motion. They learned that Morgan had been approached by Walters, which is a company that that owns and manages wedding venues and event venues throughout the Metroplex. He was approached by Walters about beginning a relationship with LaForce, where LaForce would be a almost exclusive provider of DJ services in their wedding venues. And instead of bringing that opportunity to LaForce, Morgan decided that he was going to take that opportunity for himself and entered into negotiations then with Walters to be the exclusive DJ provider for their venues. And if not exclusive, at least one of only a few that would be providing these services. And then Walters and Morgan decided to start a venture that would duplicate LaForce's business within Walters' wedding venues. When LaForce found out about this, they confronted Morgan and he was terminated. He was sent a letter reminding him of his obligations under his employment agreement. And a few months went by, and then LaForce discovered that he was performing DJ services. And that information is in the affidavit of Jen LaForce that's also attached to the motion. At that point, LaForce reached out to Morgan and Walters and had a couple months of discussions about trying to resolve this matter. Then those discussions didn't result in resolution, obviously, or we wouldn't be here. And then in January, LaForce became aware that Walters and Morgan had launched a company called Co-Host Entertainment that provides event production services and DJ services at Walters' wedding venues. That information was posted on the Co-Host and Walters social media accounts on or about January 15th. And in addition, on April 1st, LaForce discovered that Walters had hired an employee of LaForce, and he's now employed by them. The application for the TRO has been brought to this court because LaForce needs to protect its confidential and proprietary information. And when Walters and LaForce were having discussions about trying to resolve this matter, Mr. Walters told my client, Glenn Roush, that they were planning on using Mr. Morgan to train all their DJs in order to.
Ms. Harrison, I've read all the briefing.
Okay.
I have a flavor of what's going on, and I don't have a minute of time, unfortunately. So let me hear from, does Mr. Morgan have an attorney? Mr. Morgan, I see you're here.
Laura Lewis for defendant, Mr. Morgan.
Great. All right, go ahead, Ms. Lewis.
Your Honor, I apologize that we didn't have an opportunity to respond, but as you know, we didn't find out about this till late in the day yesterday. However, I will respond by, and I do have Mr. Morgan here as well as Mr. Walters, who are happy to provide additional evidence. But the fact is, the information provided in here is so false that it borders on delusional. Mr. Morgan had been in the event production business for 10 years before he met LaForce. And this issue about whether or not Walters intended to go into business with LaForce is simply not true. Never, ever did Walters want to go into business with LaForce. Not ever did they want to make this offer to LaForce. They had every opportunity to do so. They know exactly how to reach out to Mr. Rush anytime they want to, and that was not their plan. They intended to offer a comprehensive offering of services within their wedding venues. They own and operate 30 wedding venues across Texas and in Georgia. They offer catering services, and they were planning, beginning on January 1, to begin requiring that their brides buy only their catering and no longer use outside caterers. They were planning to include stationery, floral, DJ services, possibly photo booths, photography, and wedding cakes. And to that end, they began interviewing individuals who had a certain skill set that they could hire to manage that process. Walters has been in the wedding business for 15 years. They didn't need Mr. Rush or anybody else to teach them the wedding business or how to provide services to their clients. And now they do provide services to their clients, and they are not out in the marketplace competing with LaForce or anyone else. They have in-house services that are sold by their in-house salespeople. When someone comes in and wants to rent the venue, they're offered the venue, they're offered linens, they're offered different chairs, they're offered a variety of catering packages. They're also offered other services like DJs and photography and stationery and floral. And so there are a variety of services that are offered to this confined and closed market. It is not out on the marketplace. And Mr. Morgan is not providing DJ services. He is in a management position where he handles scheduling. He takes in the orders from the sales team. He is not marketing. He is not closing sales. He is receiving information from the sales team. He's scheduling it. He's making sure there's a DJ there for it. He's making sure, logistically, the operations are managed. And so this is a farce, Your Honor. He is using only the skill set that he had before he knew them. They have no right or privity or protections over the skill set that Mr. Morgan had. He went to college. He's invested an enormous amount of time in learning this trade from numerous sources outside of LaForce, and continues to gain education and learn from others in this area. And as we wholly oppose the imposition of a restraining order in this case. However, to the extent Ms. Harrison claims that he is not allowed to provide DJ services in a 4-county area, we agree. He's not to provide DJ services in a 4-county area until August of 2021, and I believe he intends to respect that.
Okay, so let's kind of look through, and I appreciate that argument. That was helpful. So I'm looking at their, let me go ahead and share screen this, and maybe this, and this is on YouTube if you guys need to go back and watch this, but let me share screen their request here for their TRO. So providing, planning, supporting, or assisting the provision directly or indirectly event production services in Tarrant. So he was a DJ before, correct?
Your Honor, that is not what he told my client. In fact, he quite opposite told my client that he had never done that before and that he needed training, and that's what my client did for him.
What did he do for your client? He was a DJ?
He was a DJ and event production coordinator.
What does that mean?
It means you run the event. The DJs don't just spin music. They run the event and act as a host and make sure that the event is going off smoothly.
Okay, so what we're going to do for A, if you guys want to take notes on this, for A, we're going to grant the TRO, but we're going to amend it to say directly or indirectly. So planning, providing, planning, supporting, or assisting in the provision of, or actually, let me just say this, A, providing and planning, sorry, just providing DJ services in Tarrant County, Tarrant, Collin, Denton, and Dallas County. So providing DJ services in Tarrant, Collin, Denton, and Dallas County. B, contacting, soliciting, or otherwise communicating with, directly or indirectly, LaForce's referral sources.
Your Honor, if I can address that briefly.
Yeah, what does that mean?
Walters was in fact a very large referral source of LaForce, and that is who Mr. Morgan is directly working with now. And Walters, previously to when they decided to have all of this with sort of captured folks, captured caterers, captured florists, captured DJs, that kind of thing, they were in fact using all those folks outside. So that was Walters is a referral source for LaForce and had been since 2015.
But Your Honor, it's not practical that they are now. First of all, he didn't solicit Walters. Walters is no longer on the market for these services because they offer them themselves. They're not a referral source. But he agrees he will not reach out to other venues. He won't talk to any other venues. All of their referral sources are theirs. He doesn't want to have anything to do with them.
What if we said contacting, solicit, or otherwise communicating with, directly or indirectly, LaForce's referral sources other than, what is your client called again?
Walters. If it could say the same thing except including Walters, it said excluding Walters, we would agree with that.
Okay, let's do that. C. Employees, vendors, and independent contractors. I would say LaForce's employees. What do you think about vendors and independent contractors, Ms. Lewis?
Our argument is that they're independent contractors. They work in a variety of places. They should be able to work at Walters if they want to. Vendors should be able to provide vendoring services anywhere.
I agree. So we'll limit that to just employees. D.
Your Honor, this is a big point for us because Walters flat out told Glenn Roush that he was going to use Morgan to train DJs to do essentially the same thing that they were doing for LaForce. So we believe that he should not be allowed to do that. And if he's not doing it, if that's what he's claiming, then there shouldn't be any harm in restraining him from doing that.
Okay. Okay, so some of these things I don't, so using or allowing any other person or entity to use LaForce's specialized training, and then you put a comma, does that mean closing any sales or closing sales related to LaForce's specialized? Is that, you say he shouldn't be able to close any sales?
He shouldn't be able to train people on how to close sales in the way that LaForce trained him how to do it.
Your Honor, they have to be, restraining orders can't be ambiguous, and this is ambiguous. How does one know if they're using the closing? First of all, he's not closing, but let's just say, how would one know if they were using LaForce's closing techniques or not? I close deals every day, and might they look like LaForce's? I've never even seen their closing techniques, but aren't they kind of all the same? You ask for the sale, you try to get them to agree.
Your Honor, Mr. Morgan knows if he's using LaForce's techniques or not.
That's not the standard. Can it be enforced by a court?
Yeah, okay, so closing sales is way too broad. Event production planning, way too broad, so those are out. Referral source relations, it's just too broad, that's out. Music theory and history is definitely out. Equipment operation setup, that's out. 6, I don't know what this means. LaForce DJ personality training, what does that mean?
There's a special way that LaForce trains their DJs to talk and host and act at an event. That's what that's referring to.
Is that in writing somewhere?
It's part of the training that they give to them. Your Honor, I don't know if it's a written document, but I know it's training that they work on quite extensively with their DJ personalities.
I just don't know what that means exactly. DJ personality training.
Your Honor, my client will affirm that he uses the same personality he's always had his whole life, and he will not change his personality for the benefit of trying to steal something from LaForce.
I think that the idea is he can't train people to act like LaForce's people, right?
Yes, Your Honor.
We agree that he will not train them to behave like LaForce's employees.
All right, so 6 is still in, and 7.
Except to the extent that 6 says microphone technique, we will teach people to how to hold a microphone and posture to please sit up straight and not walk on all fours, to not use profane language, to speak politely. And I don't even know what delivery means. So we don't agree to the IE, but we agree that we will not teach them to behave like the force employees to the extent we understand that.
Take out the IE because that is too broad. 7. I think 7 is fine with the exception of or any variation thereof. I don't know what that means, so we'll take that out, but 7 is okay. E.
I think we're fine with that, Your Honor. No problems with E.
E, F.
We disagree with that, in that he had the skills.
F is out. G is out. Okay. All right, go ahead and edit the order, Ms. Harrison, based on what I just said. Again, this is on YouTube if you need to go back and look at it. And go ahead and share that with Ms. Lewis. Let's talk about the bond. I mean, it's fairly limited what we're doing here at this point, so I think the bond should be fairly low. But Ms. Lewis, what is your argument on the bond?
Your Honor, we would ask for a minimal bond of perhaps $1,000. We agree that this is a fair and reasonable restraint that he was already abiding by.
Ms. Harrison?
$1,000 sounds reasonable to me, Your Honor.
All right, 1,000. And then do you want to go ahead and set this for TI in 2 weeks?
Yes, Your Honor.
So June 4th at, you want to do June 4th at 10 o'clock?
That works for me, Your Honor.
Ms. Lewis, Mr. Morgan?
June 4th at 10 o'clock, we'll be here.
Also, I just want to remind you guys that it sounds like there isn't that much of a disagreement at this point. Maybe you're going to want to try to expand this or something, but I would consider possibly agreeing to a TI on this. I would think that wouldn't be too hard to do. I will caution Mr. Morgan, as I do all folks who are subject to a TRO in my court, realize that if you do violate this TI, for example, let's say you go out and do a DJ event, next Tuesday and you get caught, the penalties, unfortunately, that I have that I can enforce against you are fairly limited, but they're very severe, either up to a $500 fine for each time you do it and up to 6 months in jail. So the only time I've ever had to put anyone in jail is on a situation almost identical to this, where somebody violated a TRO involving a non-compete. And so, unfortunately, as a DJ, you're fairly high profile. It's hard if somebody takes a picture of you and you're doing a DJ event, during this time period, realize that the penalty could be quite severe. I don't know if you've been to Loose Sterrett before. It's not pleasant. We can't segregate you. You'll end up, last time I sent someone to jail, he was a white collar businessman who ended up in the same jail cell as someone accused of murder. So you don't want to violate this TRO. I just want to explain that. fairly limited. It's going to basically keep you from doing DJ services. But sometimes I've seen people think like, I can get away with this. No one's going to catch me. And trust me, you usually will get caught, and the penalty can be quite severe. Does that make sense, Mr. Morgan?
Yes, sir.
Okay. Anything else, guys? Can prepare the order for me, Ms. Harrison, share it with Ms. Lewis, and then email it to Rhonda, my court coordinator, and make sure you include on it that this was heard on May 21st, 2021, when you email the new order over. Okay. Ms.
Your Honor,
Lewis?
we are willing to stipulate to a temporary injunction on these same items and avoid the bothering the court again with this matter.
Yeah, just talk to Ms. Harrison about it. She may agree to that. She may not. She doesn't have to. She may want a broader TI or whatever, but I'd encourage you guys to consider that. And you know, but if you can't, you can't. And just Mr. Morgan, just be careful. All right, guys, just get me an order as soon as you can. And Rhonda, go ahead and set that for a TI. Include in the order also the TI. Make sure it includes the bond amount and the TI time.
Yes, Your Honor.
All right, thank you, guys.
Thank you.
All right, this is a busy morning today. I believe our next case is Weaver versus KW New Vision Properties. Is everyone here on that one? I saw Mr. Mims here. Are you here, Mr. Mims?
I am, Judge. Can you hear me?
I can. Ms. Hubner, are you there? Ms. Hubner was here. You need to speak up, Ms. Hubner. Ms. Hubner, are you there? Am I muted? Can she not hear me?
I can hear you.
I can hear you as well, Your Honor. And this is Mark Tarabi. I'm here as well.
Ms. Hubner, okay. What was she going to need to say anything? Can you hear me, Ms. Hubner? Is she, maybe? I don't know. Can you guys hear her? I can't hear her.
Nope. I can see her.
I can't see her.
I can, yeah, well,
Hang on.
put in gallery view.
Oh, I can see her now. Yeah.
All right, well, Mr. Mims, let's go ahead and get started. Let's go on the record on cause number DC 201712, Weaver versus KW New Vision Properties and Land, Inc. Council, make your appearances.
Myers Mims, the plaintiff.
Your Honor, Mark Tarabi for defendants affiliated and KW New Vision.
She's talking. I don't know what she's doing, but we can't hear her. Okay. Mr. Tarabi, I'm sorry, Mr. Mims, go ahead and proceed.
Well, Judge, I'm not sure. I think we're here to approve the receiver's application to sell, if I understand correctly.
That is correct.
Which I understood that all parties were in agreement on. The only issue that we ever had was we wanted to ensure that the receiver was conveying the property and that it would not be conveyed in the name of defendant. And the title company assured us, sent us the language assuring that. And other than that, I think unless Mr. Tarabi had an objection, we actually believed that this matter was going forward without a hearing, to be honest with you, but I could be incorrect.
Yes, Your Honor. I don't think that there's any disagreement between plaintiff and defendant and third-party defendants, et cetera. So unfortunately, it looks like Ms. Hubner is unable to get her audio working. But if assuming that the both of us have agreed to it, I don't see any reason why the judge can't. Although my screen just freaked out a little bit.
Yeah, so did mine. But
No, that was me. I'm trying to share a screen. Is this the correct order of sale?
she filed one, I believe,
yesterday. Yeah,
Yes.
she amended one yesterday, Your Honor.
A new one? Okay, let me see if I have. I want to make sure I signed the right thing. Ms. Hubner, can you say anything to us?
Unmute. Unmute. Hello. Good morning.
There you go. Okay.
I'm so sorry. Pardon me. I apologize. Judge, we're here today on receiver's application for sale of real property of the property located at 2470 Ozona, formerly known as 1743 Missouri. I received I filed the application for sale, and then I had to file an amended application because the sale price didn't come in at the price we had agreed to, and it came in at $415. So this is an old order, and then I filed an amended a couple of days following this one that puts the sale price at $415. So other than that, all the conditions remain virtually the same, with the exception of we removed the seller concession of 1,000. The second amended, yeah.
Okay. Is this the right one? Everyone
This
agree
is
this is
correct.
what I should sign?
Yes, sir. This is the correct one. And I attached to this the appraisal that shows that it came in at $415. I also attached the amendments that reduce the sale price and remove the $1,000 seller concessions that we were offering.
Mr. Mims, do you agree to does your client agree to the second amended notice of sale?
Yes, Your Honor. Could you put the proposed order back up by chance?
I'm so sorry. Yeah, let me do that again.
The terms we do agree to, yes.
Is that the correct one?
That's
Yes,
the
sir.
application, but I was referencing the order that was filed yesterday. I just wanted to make sure that.
Oh, I thought that's what it was. Let me.
I think it's the one right before that on the docket.
I can't tell which one it is. Let me
That's
see.
it, right
It's that one, Judge.
This one? Okay.
Yep.
Yeah.
Is that it?
That is it. That's the proposed order. Yeah.
That's a great, okay. So do you agree to that, Mr. Mims, this order?
Yes, it's the same as the one that we had sent. Is it not, Ms. Huebner, that we had all agreed to previously, correct?
It is. The order's the same.
Yes, yes,
The only changes are the terms of the sale.
yes, yes.
And this is selling to Joel Rodriguez and Michael Heredia?
That's correct. Yes, sir.
Mr. Trabi, do you agree? Does your client agree
Yes,
to
Your Honor.
this? Okay, I'll go ahead and sign this, and then I will go on. Thank you, Ms. Huebner, for your service. Is this close the case, or do we still?
No, we need to do an order discharging me, and we'll do that Monday after closing. So I was going to see if my charming husband could come down and pick up a copy of this, or if we can get it expedited, because I can't close without it.
Oh my gosh, okay. Did not need to. I printed out. Okay, so do you want me to email? I can email it to you if you want.
That would be fabulous.
Can
I'm
you
waiting
grab-
on it to
grab one?
close. And thank them both. Mr. Mims and Mr. Trabi were great to work with. We did very well together. So I hope this helps settle y'all the case before you guys.
Okay, so
It
there's
helps
also an
give
order.
us the grounds what to fight over, I guess.
So the order disapproving sale, I do not sign that.
Yeah, it was, I gave you options.
Okay, thank you. All right, so the order confirming sale, you want me to email that order to you, Ms. Huebner, is that correct?
That'd be really great.
Can you make sure that this gets scanned and then emailed to Ms. Huebner?
Thank you.
All right, guys, great to see you. I have about 1 million other hearings, so we're gonna have
I
to
know.
get-
Have a wonderful day.
One short question, Judge,
Okay.
which is, do we have an update on in-person or Zoom trial dates? We're set for June 22nd.
So that's a very good question. We have June 23rd, and you probably have already heard that we're doing a rotating docket for June and July for the Dallas County Courts. And so the 68th day is June 23rd. So you will probably be set on June 23rd instead of 22nd.
Okay.
The next date we have is July 19th. And then after that, I'm not sure. Hopefully we'll be back to, things continue to go they are with the pandemic. I imagine we'll be back to normal jury trials in August, but I don't know that for sure. But for now, I would be prepared, and we're going to do a pre-trial, if you haven't gotten a notice on that already, a pre-trial for June 23rd, on June 22nd. So you'll have a pre-trial hearing on the 22nd, and then on the 23rd, you'll have the actual trial.
Okay. And Judge, I think I hear you saying if we're going right now, we're currently set to go via Zoom. I'm not done.
No. The pre-trial is on the 22nd is on Zoom. The trial itself is in person.
Okay, so we're going back to in person. Okay, great.
For in person, yeah, the pre-trials, we're going to have,
yeah,
I don't know, probably 15, 20 cases that we're going to have to do pre-trial on, and then we'll have to figure out which ones are actually going to go in order. But yeah, the pre-trials Zoom, the trial itself will be in person.
Got it. Thank you so much.
Judge, may I be excused?
You may be. Thank you,
Have a great day.
guys.
Thank you.
Thank you, Judge. Be safe.
Thank you. Staff care versus Parago contract specialist. I saw Mr. Alexander here. Is Mr. McCown here?
I'm here, Judge.
Is anyone else here on that case?
Mark should be on someplace.
He keeps getting in and out. I don't know what's going on with the Zoom connection, but Mr. Alexander, are you there?
Yes, Judge. Can you hear me?
Okay, we're here on a motion to withdraw. You seem to be having some internet issues, so let's get this hearing done as quickly as we can. This is staff care versus Parago. Go ahead and make your argument on the withdrawal.
Yes, Your Honor. We filed a motion to withdraw, but you mentioned correctly that the letter I attached as an exhibit advising the client, my client that is, my intention to withdraw did not have the local rules, and that was on me. That was my error. So I filed the amended motion on 5/4/21, and attached it was the proper letter, the 10-day letter. And also we filed with you the proof of service that we served Mr. Hewitt, who's the president of my client, and also with the motion, the notice of hearing, and of course, the 10-day letter. And we filed a certificate of service with you that we set in addition to e-filing and emailing. We filed with you the green card signed by Mr. Hewitt on 5/8/21. The defendant, my client, has not been contacting me in months, despite my emails and letters, emails and phone calls. They've literally gone radio silent. I can't do anything. I can't respond to Mr. McGowan wants to take depths and do discovery. My client just disappeared. So I have to be able to communicate that, completely represent anyone. And obviously I can under these circumstances. Therefore, I'm respectfully asking you to grant my motion to withdraw.
Anyone object to this motion that's on the Zoom right now? Mr. McCown or anyone else?
No, Your Honor.
Court will go ahead and grant the motion. I just printed that out. Guillermo, can you go grab it?
And I gave you an order, Judge.
Yeah, I just printed it out. I'm going to sign it right now.
Thank you, Your Honor.
All right. Thank you, Mr. Alexander. You have a good day.
May I be excused?
McCown, you have a good day as well. Be safe.
See you, Jim.
Yadira Hernandez versus Car Wash Enterprises, LLC, DBA Midway Car Wash. Anyone here in that case?
Good morning, Judge. Yeah, Kelsey Brodock here on behalf of Yadira, the plaintiff.
Is anyone here for the defendant, Mr. Downs?
I don't see Mr. Downs.
All right. Well, when do you want to try this case?
I don't have a problem maybe reaching out to Mr. Downs and finding a mutually agreeable date.
That's why we have a scheduling conference. So if you didn't show up, you get to choose.
Right. Okay. We still need to conduct mediation in this case though, Judge. So maybe early fall.
Okay. You tell me when. When would you like to do it to go?
Let's maybe look at October.
October. Okay.
Yeah.
What in October would you like?
I can do the 18th.
19th. We do trials on Tuesday.
Oh, okay. Yeah, the 19th will work.
All right, we're going to go ahead and set this for trial on October 19th. And who would you like to use as the mediator? Is this a personal injury case? I can't really tell.
Yes, it is. It's pharmacist.
Who do you like?
We can go ahead and set it maybe with Mike McCullough.
That sounds good to me. He's a great mediator. He had just started mediating when I took the bench, so I actually mediated with him a couple times. He's a really good guy, and I've heard great things about him since then. All right, we'll go ahead and appoint Mike McCullough and then set it for trial on October 19th. Anything else we need to talk about? And you can put together whatever other scheduling order you want to. If you want to do any other deadlines, that's fine with me. But for now, we'll go ahead and set it on October 19th.
Okay, great. Thank you, Judge. May I be excused?
You may. Thank you so much. Wells Fargo Auto versus Trey Smith.
Good morning, Your Honor. Matthew Davis for Wells Fargo.
Mr. Smith, Trey Smith, are you here? Okay, let's go ahead and briefly hear your argument.
Absolutely, Your Honor. This case relates to purported lien asserted by Mr. Smith for repair work done on a vehicle on which Wells Fargo has a lien. Wells Fargo filed a declaratory judgment action seeking to confirm that one, Mr. Smith does not have a valid lien because he failed to properly effectuate it. And to the extent any constitutional lien exists, it is Wells Fargo's lien is superior because it acquired its title to the property prior to the creation of that lien and without actual or constructive knowledge of the lien. I'm happy to provide more detail if it'd be helpful to the court, but that's the big picture. We do have properly effectuated service for both the motion and the notice of hearing. No response to the motion has been filed, and obviously Mr. Smith has not appeared today.
Court will grant the summary judgment. I don't see an order in the file. Can you go ahead and email that as well as e-file it? Also stay on the order that this hearing was heard on May 21st, 2021. Email it to Rhonda, my court coordinator, as well as e-filing it.
Yes, Your Honor. And just to avoid any confusion, it hasn't been accepted yet. So there was one filed earlier this morning, but I'll need to make those changes. So we'll upload a new one and email Rhonda as well.
All right. Thank you so much, Mr. Davis. You be safe, okay?
Thank you, Your Honor.
Ty Kim versus Jenda Nichols. I saw Ms. Huerta here. Is Mr. Lacrone here?
Ms. Holcomb for the Lacrone Law Firm, Your Honor.
Okay. And Ms. Huerta, you're here for the plaintiff?
Yes, Your Honor.
Okay. We're hearing a motion to compel and dismiss. Let's go on the record. Tony, are you there?
Yes, Judge.
Let's go on the record on cause number DC 2000566. Ty Kim versus Jenda Nichols. Counsel, make your appearances.
Cynthia Huerta for the plaintiffs.
Rhonda Holcomb with the Lacrone Law Firm for defendant Jenda Nichols.
All right, let's go ahead and proceed.
Thank you, Your Honor. I won't take too much of the court's time on this, and I will make a representation that Ms. Huerta has been responsive with us. We're just having an issue with getting her clients to present for deposition, and we're trying to keep this timely. So as our motion represents, we've diligently pursued her clients' depositions. They're not making themselves available. We need this court's order to get those depositions in a timely manner, and if plaintiffs continue to fail to prosecute their claim, to dismiss for want of prosecution.
Ms. Huerta.
Your Honor, I'm having something of a client issue. And I've actually not dealt with Rhonda. I've been dealing with
John Breeze.
John Breeze, thank you. And they've been abundantly patient with my office. There's an issue with my clients. And there's two clients. With Tay, I think I can get the matter resolved, but it's Andrew that I've not received any communication from Andrew. If I'm not fighting the motion to compel the deposition. I think that would facilitate getting things done. I obviously don't want to do sanctions at this point, but I would not be opposed to the motion to compel the depositions.
Okay. Do you want to maybe an order within the next 30 days, or what would be
I think that would be
reasonable?
helpful, Judge.
Ms. Holcomb, go ahead and prepare an order ordering both depositions, I presume, within the next 30 days. When you prepare the order, if you could go ahead and e-file that, as well as email Rhonda on the order. Please put it was heard on May 21st, 2021, and try to get a signature from Ms. Huerta if you can as well, agreeing to the form.
Okay, great.
Thank you,
We'll do that.
Judge.
Thank you, Your
All right.
Honor.
All right, guys. Thank you so much. You be safe.
Thanks.
All right. Good to see you guys.